Waiver agreements are a critical component of contract law that can significantly impact your legal rights and obligations. When you sign a waiver, you're intentionally giving up certain rights that would otherwise be yours to exercise. But what exactly makes a waiver valid, and how do they function in different contexts? A waiver of contract occurs when one party voluntarily relinquishes specific rights outlined in an agreement they signed. This relinquishment must be both intentional and voluntary to be legally binding. For instance, if you receive goods but deliberately reject them at delivery, you may be waiving your contractual right to those items. However, if you refuse the goods by accident, thinking they were something else, this wouldn't constitute a valid waiver because your action wasn't intentional. For a waiver agreement to be legally enforceable, 3 key elements must be present. First, the waiving party must know what right they're giving up. Second, they must intend to relinquish that right. And third, they must act voluntarily, without coercion or misrepresentation. While written documentation makes enforcement more straightforward, even unwritten waivers can be binding if these criteria are met. Courts often examine the behavior of both parties to determine if a waiver was valid. Repeated failures to enforce a right might lead to what's called an implied waiver. It's worth noting that not all rights can be waived, particularly those tied to public interest, such as certain consumer protections or labor rights. Various types of contractual rights can be waived depending on the specific agreement. These might include exclusive rights to purchase or sell goods, rights to receive payment for services or products, exclusive access to protected material, or having products delivered at specified times. However, only certain contractual duties can be transferred to third parties or waived. Waivers can be either express or implied. Express waivers are based on the direct words from the party giving up their rights, while implied waivers are inferred from conduct that indicates an intention to relinquish rights. Both types can be legally binding when the proper elements are present. Generally, silence alone cannot be considered a waiver. To legally waive contract rights, a party must either fail to complete a required act or take some positive action. Simply staying silent on a matter typically doesn't constitute a contract waiver. However, there are nuanced exceptions where courts might interpret prolonged inaction as an implied waiver, especially if the silent party benefited from the other party's performance without objection. Standard waiver agreements often contain several important clauses. A non-waiver clause ensures that failing to enforce a right once doesn't result in permanently losing that right. An entire agreement clause states that the waiver supersedes prior agreements related to the waived right. And a choice of law clause specifies which state's laws govern the waiver. Including these provisions helps define the scope of the waiver and reduces potential disputes. Waiver agreements appear across numerous industries. In real estate, a tenant might waive the right to break a lease early in exchange for reduced rent. In freelance work, a client could waive their right to penalize late delivery if the freelancer provides additional services. For intellectual property, one party might waive enforcement of copyright clauses in licensing agreements. And in distribution contracts, a supplier might temporarily waive minimum order requirements during supply chain disruptions. It's important to understand how waiver agreements differ from similar contractual modifications. A waiver relinquishes a right without changing the entire contract. A release, on the other hand, terminates the entire agreement or a specific obligation, often as part of a settlement. An amendment formally changes the contract terms and typically requires agreement from all parties involved. To create a legally sound waiver agreement, use clear, unambiguous language. Define the scope and duration of the waiver. Include signatures from all parties and the date of execution. Specify the jurisdiction and governing law. And for high-value or complex contracts, consult legal counsel to ensure your waiver will hold up in court if challenged. Remember that a waiver doesn't usually cancel an entire contract. It typically applies only to specific rights or obligations within that agreement. The enforceability of waivers varies by jurisdiction and the nature of the rights being waived. When in doubt about creating or responding to a waiver agreement, consulting with an experienced contract attorney is your best course of action to protect your legal interests.